they can't change the alimony amount, right? Because you stipulated to that. So each time you stipulate something, it narrows their ability to utilize the statute. Same thing with having, an agreement in general. If you have an agreement, then that restricts the jurisdiction of the court to even rule over the matter.
Absolutely.
So just keep that in mind because I just kind of, after all these years, it just dawned on me that, these guys, they want to try to expand their authority at any turn, whether they mean to or not. I mean, maybe they're fatigued or whatever. I don't know, but it seems like in my case, every turn they're trying to expand their jurisdiction and they don't have the authority to do so. And that's all I wanted to say.
What you're saying is impermissibly expand their authority, even beyond what the rules may allow a judge to do. And sometimes judges have discretion to do certain things, but what we look for is statutory language that is clear. And again, this is not legal advice. This is just what I do. But if you talk to your attorney, which I always suggest, and again, I try to say nothing disparaging about attorneys. I'm saying something specific about these attorneys because they are opposing counsel and their conduct is undoubtedly reprehensible. As you see right here on number 5, which is really part of the focus of what I'm talking about, is the plaintiff. I don't know why they say it. I guess it's some sort of form document. The plaintiff, who we know is me, shall voluntarily, which we'll get to this part, voluntarily dismiss this litigation with prejudice. As we see, this litigation only involves these people. The fact that these other people are on here doesn't really matter because they're not a part of that litigation. What happened after we did this stipulation, which is not a mediation settlement agreement, but a stipulation, is the attorney for State Farm shortly thereafter, it won't be on this one, I'll find it on the other one. Shortly thereafter, filed a release or signed a release. I'll find it for you all, where I was supposed to get rid of a whole bunch of other people and some other things that had nothing to do with the litigation against the Tuckers. And in doing so, that brought us to right here, which is an order where the judge finds that I signed the stipulation, and the court ordered shall sign the release. The release, I'm about to pull it up, contained additional language. And you see that blue part where it says, should the plaintiff fail to sign a release? And there was a pretty contentious hearing where I said, I'm not signing the release because the release does not mirror the stipulation. But should I fail to sign it within 10 days of the order, it shall be enforceable as if I had executed the release. Essentially, Judge Emily Ann Peacock ordered me to sign something against my will that I had no desire to have. Then they came back on the back end when I sued them for what was called fraud in the inducement and argued I agreed to voluntarily sign or release the parties, which is this is what we're coming to on Monday, is their motion to supposedly dismiss the action for those reasons, and that Mr. Doss, they actually even try to get sanctions on me, which that's not going to go any goddamn where because Brett, you want to tell them the part that we learned about for them to be able to be sanctions? What has to happen for an action to be frivolous?
Yeah, hold on one second. Let me pull up that case law.